Dear learners, welcome to this course. In patent, we discuss about different things, and as a librarian, what should you know as a librarian of a patent? So the heading is Patent One Must Know. It is very important that as a librarian, you should know that what is patent. Normally, when we interact with the librarian, it is something very different because, as I remember my childhood, when I was very small, I used to go to my school and there we had one lady librarian. So, twice I did not bring books on time, and at that time, we used to pay extra or fine for not paying or not bringing the books on time. So that makes you disciplined. That also inculcates a reading habit because you are very much interested in a particular subject or a story or a novel, and you just take that book from the library. So it is not that you can just keep that book for yourself for a month or so or a year or so. You should return the book on time. And the importance of having a social life. We all say that we are a socialist state. Library is a big example of reaching out to the people. One book reaches in the hands of so many people. So as a child, the librarian made me understand the importance of giving the book on time. She also made me understand that it is very important that we remember things and we be disciplined because discipline is a part of life. When I talk about patent, after seeing this video, you will be able to define and explain the need of patent, discuss the patent rights and importance of patent, explain what can be patented and what cannot be patented in India, discuss the procedure for filing patent application in India. What is the need of patent? First is to protect the intellectual property for 20 years. As an inventor, I have invented something, so I will have that right for 20 years. During this period, no one can, manufacture the product without my permission. I will also get royalty for my invention, and after 20 years, the invention will go in the public domain and competition can be blocked by this. Now, the question is, what is patent? It is a statutory right to the inventor for his invention, which is either a new process or product. So, as an inventor, I have invented something. So, the statute gives me the right over that invention for a period of 20 years. It has a timeline. So, I have invented something today, and even after 20 years, I say that, I have that monopoly. It is not done because after 20 years, that thing will go in the public domain. So, you are getting benefits out of your invention and then you have to part away with that benefit because that is for social good. It is granted in lieu of sufficient disclosure to the patent offices. It is a territorial right and it is also called a negative right. To prevent third party without authorization, there are certain patent rights. First is to make or manufacture, to use, to offer for sale, to sell, to import, to distribute, to get license. So very important, I have invented something, so I will have that patent right to make or manufacture that thing. I can use it, I can offer for sale, I can import it, I can distribute it, and I can get a license. Is patent right absolute? No, nothing is absolute. All the rights have reasonable restrictions, so nothing is absolute in this entire world. So government can use it. It can be used for experimental purpose, the COVID vaccines. It can be used for research purposes. It can be used for teaching purposes. It can be used in government hospitals or medical institutions for distribution of drugs or medicines to the common people. So if that drug is very important for the commoner, the government can distribute it. So this right is not absolute. It can be used by foreign vessels, aircraft, land vehicle which have temporarily or accidentally come to India. So in case of emergency, the government can use it. The teaching institutions can use it for research purpose. Your invention can be used, and even for the experimental purposes. So this patent right is not absolute. It has these restrictions. Importance of patent. It encourages scientific and technical literature, because if I give you a right for 20 years, then you will be motivated to invent more, and the country will grow as a country, as a globe also. In terms of technology, we will grow. It also avoids duplication. It paves way for future inventions. It stops reinventing the wheel, identifies emerging areas in technology, treasure house of scientific inventions. So you too have to understand that importance of a patent is that you get this right for 20 years. So there will be no duplication. Future inventions, you will be motivated, even your colleagues will be motivated to have future inventions. Then you will not reinvent again the same wheel. So if I have invented something, my colleagues can use it and experiment with it and invent something which is better than my invention. And it also enriches you in technology, and this is a treasure house of scientific inventions. Subject matter of patent. Many a times people ask, what is the subject matter of patent? Patent can be of any article, apparatus or machinery or its component, any substance whether living or non-living, product, pharmaceutical product, any composition of matter, pharmaceutical products, any process, manner or art of manufacturing other than essential biological process. What is invention? The Patent Act 1970 defines invention under section 2(1)(j). Invention means a new product or process involving an inventive step and capable of industrial application. So invention is always something new, or a process involving an inventive step and capable of industrial application. What are the patentability criteria? It has to be novel, it has to be new, it should be non-obvious or should have inventive steps. So something which everybody knows cannot be patented. It should be capable of industrial application. It should not attract the provisions of section 3 and section 4 of the Patent Act 1970. So we will discuss 3 and 4 later on. So it should not be which is prohibited by the law. What cannot be patented in India? An invention which is frivolous or which claims anything obviously contrary to well-established natural laws cannot be patented. An invention, the primary or intended use or commercial exploitation of which could be contrary to public order or morality, of which could be contrary to public order or morality. This is very important, That's something which you want to invent and that is contrary to public order or morality, or which causes serious prejudice to human, animal or plant life or health or to the environment, then you cannot invent that thing and you cannot ask for patent. The mere discovery of scientific principle or the formulation of an abstract theory or discovery of a living thing or non-living substance occurring in nature cannot be patented. So you have to work on that. it should be new and it should have some of your efforts. The mere discovery of a new form of a known substance which does not result in enhancement of the known efficacy of that substance, or the mere discovery of any property or new use for a known substance, or of the mere use of a known process, machine, apparatus, unless such known process results in a new product or employs at least one new reactant. It is very important, whatever is existing, if you discover that and you do not have any add-on to that, so you cannot say that you will get it patented in your name. A substance obtained by mere admixture resulting only in the aggregation of the properties of the components thereof, or a process for producing such substance, the mere arrangement or rearrangement or duplication of known devices, each functioning independently of one another in a known way, a method of agriculture or horticulture, any process for medicinal, surgical, curative, diagnostic, therapeutic, or other treatment of human beings, or any process for a similar treatment of animals to render them free of disease or to increase their economic value or that of their product, cannot be patented. Plants and animals in whole or any part thereof other than microorganism, but including seeds, varieties and species, are essential biological processes for production or propagation of plants and animals, cannot be patented. A mathematical or business method or a computer program per se cannot be patented. A literary, dramatic, musical, artistic work or any other aesthetic creation whatsoever, including cinema, television, cannot be patented. So, what cannot be patented, is clearly mentioned. So, there is no doubt that what we can get patented and what cannot be patented. Still, lack of legal education by the scientists and by the people who are working for inventions or in the labs in the universities often tend them to work on a thing and then they feel that it will be patented in their name, and later on when that is rejected, then they are demotivated. So, one should know what can be patented and what cannot be patented. A presentation of information cannot be patented. Topography of integrated circuits cannot be patented. An invention which in effect is traditional knowledge or which is an aggregation or duplication of known properties of traditionally known component or components cannot be patented. Who can apply for patent? The first or the true inventor can apply for patent. Assignee of the first inventor can apply for patent. Legal representative of any deceased inventor can also apply for patent. So, in case where your family member has been working on something and after his or her death, you as a legal representative want to get it patented, you can also get that thing patented because that person has put in so much of labor and efforts and his education, his time, energy. So, that should not go in vain because he is no more to get the benefits. How can one apply for patent? A patent application can be filled with Indian Patent Office either with provisional specification or with complete specification along with fee as prescribed in Schedule 1. In case the application is filled with the provisional specification, then one has to file complete specification within 12 months from the date of filing of the provisional application. It is very important that you meet the timeline. There is no further extension of time to file complete specification after expiry of said period. patent can be filed in Hindi or in English language only. There are 4 patent offices in India. One is in Kolkata, the other is in New Delhi, Mumbai and Chennai. What are the types of patent application? The first is provisional application, the second is ordinary application, third is convention application, fourth is PCT international application, fifth is PCT national phase application, then the next is patent of edition and the last is divisional application. So, these are the types of patent applications. Timeline, filing of complete specification following provisional specification within 12 months, statement and undertaking within 6 months, request for examination within 48 months, declaration of inventorship with the complete specification or within 1 month from the date of filing of the complete specification. Time for replying to the first examination report, 6 months from the date of issuance of FER, extendable up to 3 months, total 9 months. Pre-grant opposition after publication of the application and any time before the grant of patent. Post-grant opposition 1 year from the date of publication of grant of patent. Reference to deposit of biological matter within 3 months. Furnishing information relating to working of patent is every granted patent within 3 months from the end of every calendar year, i.e. 31st March of every year. Therefore, submission of working statements for calendar year 2017 due date is 31st March 2018. So, by this example, you will understand that the working statement of 2021 will be due next in 2022 31st March. How can one file patent application? It is very simple. You can file it online by visiting the website www.ipindiaonline.gov.in/online. You can also file your patent application through post. You can also visit any of the 4 patent offices and submit it by hand. Stages of patenting procedure: filing of application at the patent office, filing of request for examination, publication, examination, pre-grant opposition, grant of patent and post-grant opposition. In the end, I would just like to summarize this, that it is very important that whatever rights you get as an inventor are not absolute. You can file your patent application in a very simple way. So, please have patent attorneys or people who are skilled and qualified to file your patent, because if you leak your information or your invention to a third party and that third party cheats you or shares your information with other people or your competitors, it is very difficult to prove that this invention was in your name and your efforts go wasted. As a librarian, you have a much bigger role that you can educate people, because in library, we have different kind of interaction. Every discipline wants to interact with the librarian. So, you can also create legal awareness about patent filing, about that the patent rights are not absolute, and also you can file your own patent. Thank you all. Have a great day.